municipalities are to plan for public works, public infrastructure, that is roads, sewer, water, community centers, schools, hospitals. This is not to be implemented on your private property. So if they have passed an official plan that violates the Planning Act because they are not reading the documents in their entirety, this is the whole thing. Court case after court case after court case. When people lose, the judge keeps saying to the lawyers, you must read the document in its entirety to know and understand the intent. And when you are reading that document refers you to the Municipal Act, the Building Code, the Provincial Policy Statement, the Conservation Authorities Act, the Conservation Land Act. It refers you to the Highway Traffic Act. And if they are not, in turn, reading all of those documents in their entirety, then they are not knowing and understanding the intent of the Planning Act. And the whole intent of the Municipal Act and the Planning Act is the municipalities only have the lawful authority to plan for what belongs to the municipality, and that includes all of its boards. And as for the conservation authorities are the creatures of the municipality because the municipalities have the authority to dissolve the conservation authorities.
I was a politician at one time, and that was what I was advocating.
We need less legislation.
I applaud the work that the OLA is doing, and I thank you very much. It was very, very informative today. Thank you.
Take a question on this side, and then we'll come back to this side.
I apologize if I don't speak loud enough. So my understanding is our land patents give us our absolute right to our properties. Gotta put these back on. We do not have to apply for permits because it is our property, so we don't need their permission to do anything on our private property, right?
Not the municipalities, but there are common law responsibilities that you all need to understand. I better do that. So, you cannot do something on your property that is going to injure your neighbors. Blackstone, if you can, get a copy of Blackstone's commentaries. It's 4 volumes. It's Old English. He was the grandfather of common law. Sir Edward Coke was the great-grandfather of common law. In Blackstone it states, you cannot do injury to your neighbors. You cannot pollute the streams, you cannot block up the streams, that you will deny your neighbor's water. You cannot flood out your neighbor. You cannot have the eaves trough from your house pointed that it will send water onto your neighbor's property. You cannot dig so close to the property line that you will actually have their soil dump onto your property. That is theft. It's a trespass. You cannot build your house so close to that property line that you will infringe on your neighbors by doing any form of maintenance or even passing by. If you are building on a small lot, your small lot can only be a minimum of 65 by 165. That is so you have the capacity for a well and a septic that will not contaminate your neighbors. You cannot build your homes or your buildings so tall that, as she said, it will block out the ancient light. This is why the majority of houses are restricted to 3 floors. All of these setbacks, all of these requirements that they have under these municipal bylaws, these are all just policies and advice to you, the private property owner, so that you will not be sued by your neighbors. How it got to this point is, like I said previously, no one is reading the legislation in its entirety to understand it. Our municipal representatives, when we elected them, were the advisors. They were the fathers of the community. If you had a problem with Sam and his dog next door, you'd go and you'd talk to the councillor or the mayor. He'd go over to Sam and say, look, Sam, Joe's got a problem with your dog. Keeps running on his property. You know, if you keep letting that happen, well, we're going to have to get the bylaw inspector to catch your dog, and then you're going to have to go and pay the fees at the pound. So keep your dog off of Joe's property. Or if it was something bigger than that. But this is the whole thing. Because people have not been standing up for their rights, because Sam has let his dog run onto Joe's property, because people have pushed and pushed and pushed the limit of what they could or couldn't do, government feels, and don't be offended by what I'm going to say, government feels we are all too stupid to look after our private property. When in fact, for the last 200-300 years, we haven't been doing too bad of a job. And as I've stated before, this has absolutely nothing to do with protecting the environment. It has nothing to do with protecting the water, the trees. This has to do with cash and control. As it stands now, I did a tree cutting bylaw paper. 2 counties have refused to pass tree cutting bylaws because now they know that they cannot legally pass tree cutting bylaws. 1 other county has rescinded their tree cutting bylaw because no one had actually explained to them the sections of the Municipal Act, sections 11 and 12 of the Forestry Act, the letters patent, section 92.5 of the British North America Act, or section 109. Now they have that information, and as the warden said, if we pass this bylaw the way it stands, this is either immoral or completely illegal. That's what people have to start doing. They have to start taking time and explaining to their councillors, hey, this is why you can't do it, or you can be sued. You're breaking the law. That's why I'm writing these reports. So, in regards to permits, you're on your own, baby.
Okay.
Can I respond to that? Can I respond quickly to that? Your crown letters patent are your root to your title, your possessory title. So from that is a chain of deeds passing from assign to assign, or heir to heir, or heir to assign, all the way through your title, right back from the crown. So as Liz said originally, the crown reserved unto itself certain specifications or not. It'll all be listed in your title. So can you, from the previous landowner, for example, whoever you purchased your property, I'm going to assume you own property, whoever you purchased your property from, can they come back to you now and say, I really meant that shed that's out the back there in your property, I want that now, even though it wasn't in the deed and it wasn't stated that it was reserved to them? You know, would you give them the shed, or would you say, no, that wasn't part of the deal? No, exactly. So that crown letters patent is the root title to the original title to the property that then became passed on from landowner or property owner to property owner. That's what a crown letters patent is. It's also a statutory instrument listed as one of our federal statutory instruments.
It's a crown instrument.
How many go? 14 one?
Well, sorry, just let me finish
Yeah.
here. The other part of your question was, do we need permits? Question back to you. If you look at the building code, it states in the building code that the minister has to approve every single form, every single permit, the wording in the form and permit. That's a flag. Why? I'm like a 2-year-old. I want to know why. Why does the minister have to approve every single permit? And you'll notice in the small lettering, in the very, very, very small print, they're called a construction and demolition application. Okay? They're not called a permit. They're called a construction and demolition application. okay? So if you look at everyone, and I challenge all of you, go on your municipal websites, find the construction and demolition application, which is essentially, they call it a building permit. And look at the very, very, very fine print in it. And they all say the same thing. They say that by your personal information, meaning your information and your signature, that application allows them to enforce the building code on you.
Okay.
So if that's the case, then which is first, chicken and egg? Is the building code applicable to you, or is the building code applicable to you because you applied for it?
Isn't she smart?
Yeah, very. So what I was just kind of going through that to get to my real question, which is, I'm sorry,
That's okay.
so once we have, or whether we have or not have our land patent in our hands, our land is our land, nobody rules on it except for us. So why do we pay property taxes?
Oh, here we go.
Do we have to pay property
There's always
taxes?
one.
Is there a law that states we have to pay property taxes?
Yes. And the reason that you all pay property taxes is because you are actually paying for the maintenance of the roads and the services that are provided to you by the municipality. It is a corporation, and you are paying that corporation for services provided.
Now, recently, the municipality sent out a detailed report on what services are being provided for our tax dollars. And because we live in rural Ontario, we are not getting hardly any of these services. So should we be paying for these particular services?
You have a right as a property owner to defend your title against the whole world. You're the only one who has the right to defend your title against the whole world. That's to go back to your original comment or question that you made earlier. You also, as a landowner, have a right to go back to MPAC, for example, and get your assessment lowered. You can also, in the chock-a-block full of the Municipal Act, is the authority for the municipalities to deal with you on an individual basis. So you can actually apply to your council to, negotiate what your tax rates are, or, what you're paying through your assessment through MPAC. So there's lots of things that you have at your hand and your disposal to do. If you and your neighbors feel the same way, there's power in numbers. You should essentially be going back to your municipality and saying, look, at our assessment, we're not getting these services, but the mill rate that you're assessing us at is the same as these people over here who are in an urban area, but they're getting all those benefits of that service, but we're not getting that. So you're essentially discriminating against us who aren't having these services by giving us similar or very, very close mill rates. But it's based on assessment times mill rate, right? For what you're actually paying in taxes. So if they're setting a mill rate at, 0.00582179, whatever, for the mill rate, and you're assessed at $200,000, that's, $200,000 times that 0.005, that's what you're going to pay on your assessment, right? So it's the mill rate that the municipality sets, not the assessment. That's done through MPAC. So if you've got an issue with the mill rate because of services, then you have every right as a landowner, and I would say power in numbers again, to go back to the municipality and say, rethink this.
Okay, and I got a second question for you. I'm part of one of the municipalities that have declared themselves not willing hosts. We were at a Niagara region meeting last night, a couple of nights ago, Thursday night, and the Niagara region supported the townships that have declared themselves as not willing hosts. Now, the mayor, one of the mayors of Grimsby, came out after we all left and came out and declared the Niagara region as a willing host. Can they do that? Is that not a counselor, sorry, she wasn't a mayor, she's a counselor. Can a counselor do that when there are a few municipalities in the region, thank you, that have declared themselves not willing hosts?
So did the counselor speak for the rest of council, or was this a council entire decision?
She presented it to pass a motion to declare.
Council in session. They were in session.
They were in session, yes.
Yeah, absolutely. A council member can speak up and say put forward a motion and do as they wish. It's up to the, electorate to deal with their elected representative or deal with the council as whole.
So this is the Niagara region. So we have to go back to the Niagara region and say, we are not permitting you to declare Niagara region a
Did
lone
the rest of
host?
the council accept your motion and pass it?
Yeah.
No.
Okay, so she's just stating something publicly.
She's just trying
Yeah.
to do politics and go, I'm kissing the wind turbine big boy's butt right now, so I'll get lots of elected.
You must have been there.
Say the last part.
All she's doing is kissing the big wind turbine butt so she can get money to get reelected.
Can she say that? There's nothing that's legally that prevents her from having an opinion to say
Yeah,
that.
she can say that, and if the rest of the council disagrees with her, they have every right to say, not a hope.
And if they agree?
If they agree, it's up to you guys to put them under the microscope. It's up to you guys to say, we do not accept this. You want to get reelected? I don't think so. And because now you know that we do not want this, if you do enact a bylaw, particularly if you have petitions, what is that, 350 or 250? 230 of the Municipal Act, petitions. If you have petitions and they still pass it and you have grounds, real legal grounds to want to stop this, then you have the petition. If they aren't listening to you, then that is bad faith, 448.
Yes, ma'am.
It's my understanding that decisions that councillors make, that they have an ethical duty and a legal obligation to protect our health, our safety, our environment, and our property values. So if the municipality issues a building permit for something that affects our health, our safety, our environment, or our property values, how do we hold them responsible?
Well, well,
Yeah, but give me more direction.
and you're probably, this is off getting water for us, so I'll answer until she gets back, unless she wants to answer. Essentially, I'm thinking you're referring to the Green Energy Act and municipal councils, and yeah. As I said before, I've attended a number of the multi-wing municipal council meetings, and I am of the opinion that the municipalities need to grow some and get together and actually launch a legal case and a legal challenge against the province, because the province, through the Green Energy Act, has legislated a lot of their rights away, which has legislated a lot of ours. And I agree with you, in the Municipal Act, it tells them that they have to protect health, property, private interests and what have you. So it's my personal belief that I think that municipalities need to be pushed to enter into that litigation field, and the municipalities themselves that have declared themselves unwilling hosts and that are affected negatively by the wind turbines. If that's what they need to look at, then that's what they should be stepping up to do. If that's what the people want, instead of just saying we can't, our hands are tied because of the Green Energy Act. Well, then if it's the Green Energy Act and you've got a massive amount of your ratepayers in your community that are up in arms about this, then do something legally about it. Take on the province.
Actually, two reasons I know the Green Energy Act is unconstitutional is, okay, the province and a lot of lawyers and judges and so on and so forth will say to you, the provinces are the creatures, the municipalities are the creature of the province based on section 92(8) of the British North America Act. So the province is capable of creating letters patent, incorporating that municipality, making it a corporation. Once those letters patent are created and that corporation is a functioning corporation, the only authority that the province actually has is to dissolve the municipalities. Okay?
Okay.
So, the province has created a document that is infringing on a municipality's ability to do what it was created for. This was brought up at an anti-wind meeting in, I think it was either Grey or Bruce County. I wasn't there. I was told that a lawyer stood up and he said, listen everybody, the Green Energy Act is unconstitutional. But unless our municipal councillors are going to say, we don't care if you cut off all of these grants that keep getting us farther in debt, we are going to challenge you in regards to the Green Energy Act. And that's what it boils down to, folks. You have staff advising council, we need these grants and we have all the paperwork filled out, you just have to sign it and we're going to get millions of dollars. Except for it's going to put our municipalities even more $1 million in debt. The carrot. That's what it is. So, these municipalities are going, oh my God, our grants will be taken away. In regards to the official plans, if they don't pass official plans, the province has threatened them with not receiving their gas tax transfers. I have the documentation on that statement. I have the proof. I can say that. The gas tax transfers come through and are administered by the Association of Municipalities of Ontario. They do not have the right, this association that was created by the municipalities for the municipalities, they do not have the right to dictate to the municipalities policy from the province. It is to be the other way around. Not only that, the gas tax transfers comes, the majority of it, from the federal government. And the official plans now, we all know, must be for public works, public properties. So, until our municipal councillors realize that if they continue going forward, getting the grants, and being worried about being cut off from the money bags, as Mark Henderson, Reeve of Jocelyn Township states, if the province is going to be denying my citizens their lawful funding, I will see the province in the Superior Court of this province to the Supreme Court of Canada. I have the email. You are all entitled to that funding. Unfortunately, our municipal councillors are not made aware of that. So, tell your municipal councillors to get a backbone, like she said.
I just have one, I just want you to back up a second. If the municipality issues the building permit, then are they part of the lawsuit that you have against your neighbor for doing things on their property that have a negative impact on yours, which is, you know, your health, your safety, your
Cindy
property?
already covered that because it's at the approval of the minister. The building code is not administered by the municipality. They are only the hirers, the one that forks out the money for this guy that is actually implementing provincial legislation. It's right in the building code. So this is the province. It's not the municipalities. They are merely the kiosk that you go pay, where you sign the documents, because you are actually entering into an agreement with the minister, not the municipality.
If there's anybody in here who's actually a municipal councillor, you'll probably know that if you've gone to the building inspector or the chief building official and asked for the name of the property owner or the information, you know, that would identify the property owner, they won't tell you. Even though you're the municipal councillor, they won't disclose that information to you. They'll tell you it's private. The chief building official gets to know who it is and gets to know the private information, but not you as a municipal councillor. Why? Again, that's my 2-year-old. Why? okay?
Good
So,
que- Okay, gonna move on. Question on this side? Yes.
This is the last time I saw a legal document, it stated that we were a tenant in common or something to that. We're not really an owner, so we don't really have rights, do we?
are you referring to like a deed, or what do you mean legal
Yeah, the
document?
lawyers, it was
You're a tenant in fee.
tenant in fee, that's what it was.
So if you are a tenant in fee, you are a freehold landowner in fee simple absolute. Fee simple absolute is the highest ownership of property, estate, next to a lital title. Only the Crown can have a lital title, okay? The reason it states you are a tenant in fee simple is because, say at a time of war, eminent domain has to be in play, which means if the military needs it for the defense of the country, they can take over your property. They can tear down your fences. They can use the Kaiser's Royal Hotel for a headquarters. But even under the War Measures Act, they must pay fair compensation. This is why I have the statement from the Kaiser's Royal Hotel, that since Magna Carta, the estate of the subject in lands and buildings has been protected from the prerogative of the Crown, because the legislators had passed regulation that during the war, and this is during the First World War, the legislators, the government, would not have to pay compensation for any abuses or any injurious effects or any use of someone else's private property. De Kaiser's Royal Hotel challenged that under what's called a mandamus. De Kaiser won because the Queen cannot infringe without paying full and fair compensation for the use or injurious effect on that property. That's why there is eminent domain, and it is for as a last resort. This is why expropriation is an absolute last resort, because they are not in any way, shape, or form to take your rights, your property, your use from you. And when you get Blackstone, it explains eminent domain, because the public interest is more interested in the protection of the private individual's rights than anything else. So that's where the tenant in fee comes from. I hope I explained that right.
We have time for two more questions.
I just get in.
Here. Just 1 second. The next gentleman, and then take your question. Okay.
We recently bought a house and property